I have with me Barrister Sanusi Musa, and of course he is the National Publicity Secretary of the NCAN, Nigeria Consolidation Ambassadors, and of course,
National Coordinator.
okay, you are the National Coordinator of NCAN. NCAN is saying there is a bit of what they describe as a lacuna in the Electoral Act, and of course certain sections do not go down with the NCAN. One of those sections is Section 25, which seeks to substitute Section 37 of the Principal Act and Section 143. And of course, issues about substitution really worries the NCAN. National Coordinator of NCAN, Barrister Sanusi Musa, welcome to Situation Room.
Thank you very much.
Yes, it's good to have you. I have been following some of the issues you've raised about the Electoral Act,
Yeah.
and of course the issues that the court seems to be giving you a very difficult time. Can you throw some light on some of these issues?
You see, recently the National Assembly have passed the Electoral Amendment Act, which seeks to amend the Electoral Act 2006. And they made some provision there, and if you go through the Amendment Act, I think those provisions are inimical to democracy.
Okay.
And it is good for Nigerians to look at the act critically, so that because the way they present it to the public is not what really is embedded into the act. For instance, the new Section 87, which they are trying to bring into the act. They went a whole hog to say that they want to now use an act of National Assembly to micromanage a political party, making provision on who will be delegate to the primary election of a party. That is not the duty of the legislature. That is not what the Constitution envisaged under, I think, item 56 of the exclusive list, when it is given the power to legislate on issue of political parties. Because if that the issue, the Constitution couldn't have said that the parties should have a constitution. Now, for selfish interest, you now go and list people and say these are super delegates. You say all former members of National Assembly and serving members of National Assembly who belongs to any political party are super delegates to any primary election that should be conducted by delegate. It doesn't make sense. Parties should be allowed to determine who are to be delegate to their primary election.
How do they determine who should be? Because you cannot take away the overriding power of a state governor. Those are issues. And also, I am quick to cut in because I am concerned about the fact that when the National Assembly wants to make a law, it declares a period open for public hearing on issues. Where was the NCAN at this point when these particular issues were brought to a public hearing, where you should have made your representation known?
When did they, this amendment they passed, when did they call for public hearing?
Okay.
In fact, let me even tell you, when we go stricto sensu to the provision of the Constitution, the President returned the Electoral Act without signing it when the National Assembly was in recession.
Was in recess.
Okay. When it was in recess, that letter was presented to President of the Senate and the Speaker of the House of Representatives.
Okay.
Without the calling for the session of the National Assembly to read out the letters of the President, the President of the Senate and the Speaker refer the matter to their various committees that oversee. Yes. The question is, was that letter really communicated to the two houses of the National Assembly before referring it to the committee? It is not the duty of the principal officers to refer such matters to the national to the committee.
Okay.
My understanding is those letters ought to have been read on the floor so that the Senate and the House of Representatives can now take an action on referring the matter to the Assembly. But they quickly went and referred the matter while the House is on recess to the various committees, who now said they have worked on the new amendment and now they want the President to pass it. So in other words, when the President returned the bill, to the National Assembly, it has not yet even been read before the National Assembly.
Yes.
And yes, I agree with you.
Okay.
They ought to have called for public hearing. Because if you read the decision of the Court of Appeal in the case of President against the National Assembly, that's what this says. Because the phrase there, I think, under section, is it 56 or 57, is where the president returned the bill, it shall be passed again. And that pass again was interpreted in that case, and the case of Tijani against Adamawa State House of Assembly, that the process of legislation must be followed. That is first reading, second reading, and third reading. Now,
before third reading, you go to public hearing.
Yes.
Then you come, if there are issues and certain discrepancies you've noticed within the bill, it is corrected.
Exactly.
Then it's taken to, if there are differences in the version of the House of Reps and that of the Senate, you go for a unification where you clarify all anomalies.
Exactly.
So you're saying the National Assembly faltered in that area?
Of course, and mark you, when they passed the new bill, what they presented to the public as these are the issues that they have put in the bill.
Is this not the same bill Senator Itainang, the liaison officer to the president on the Senate, said had some anomalies that has to do with maybe some issues about discrepancies in the wordings and all that?
I don't know. I don't know what he said about that. But what I'm trying to say, this bill, when they pass it, you know, these are issues that are very important. Okay. And more important is their attempt to substitute Section 143 of the Electoral Act 2006 with new one. Okay. You know, as it is today, the courts have now become more proactive, where they found out that somebody, a legislator, rigged his way into a public office. After nullifying his election, he is now ordered to pay all the money he collected. Okay. Now the National Assembly, by abusing their legislative powers, they inserted under a new section 43 that if court nullifies the election of a member, he should not be ordered to refund the money he collected.
Yes. What is actually wrong with that? I am forced to ask why. Let me clarify some issues. There are also other things I want to clarify, but let me clarify this first. Yeah. If a man has been elected to come to the House of Representatives, the very primary duty of a lawmaker is to make law oversight. And of course, attend, the course of making law, he must attend the sittings. And is entitled to what comes to him on the sitting. Yeah. Now, if there are pre-election matters that were not found at the early stage of the tribunal, and the man eventually finds himself in the House of Representatives, do you fault the man? For example, if he has spent 3 years and this court suddenly comes and announces and says the issue has to deal with pre-election matters, which should have been seen to in the last 3 months before even swearing in. Now, another thing I want that you've raised about some of the faults you've raised is the issue of attempts by the National Assembly to micromanage the affairs of political parties. Yeah. And you talked about primaries. Now, in the case of this last primaries that took place, the current ruling party came out and said, the APC came out and said, we want direct primaries. Initially, it had said, okay, some states can manage indirect primaries. But because it saw the body language of the party, it said direct primaries. How is the National Assembly attempting to micromanage when the party can come and say, yes, we have our own constitution too? The grand norm is not being followed. The party's constitution now overrides and, of course, leads the people to primaries. If there are faults, do you go back to fault the constitution of the land or the Electoral Amendment Act? Okay.
Let's start from the other issue that you raised, for somebody being ordered to refund the money he collected. Okay. You see, the courts, the judges are conscious of what is happening in this country. This is a country whereby somebody will do whatever it is to rig his way into the office. Just because, you know, he might say there are 3 years collecting everything, and at the end of the day, when he's declared not to be in that office, then whatever he's had taken, it becomes his. Okay.
Sorry, if his action, for example, is criminal, he has, you know, he came in with fake results, you know, maybe he didn't go to university, or maybe somewhere along the line he had to cut down, he cut short his educational career, and yet he forges a document and says, yes, I have a PhD somewhere that people cannot trace, like in the case of some lawmakers that we have seen. Now that is criminal. If the man has to go through a criminal process, you know, to call for repatriation of some of the things he has achieved. Maybe he has built an hotel.
There are two different things.
Okay.
The proceedings that lead to somebody leaving office is not criminal.
Okay.
It's a civil in nature. Okay. And the order the court will make in such situation is for him to relinquish that seat. And with the powers of the court and its inherent powers of the court, under Section 6 of the Constitution, now they went further. When they ordered that, yes, they found out that you rig your way to the office. Okay, the taxpayers' money that you collected, which you use illegal means to collect, return it back.
Okay.
That is what they are saying.
I agree with you when you said rig the election.
Yes.
Exactly.
Okay, now the National Assembly is coming by putting a new section 143 of the Electoral Act to say, no, the court, you have no power to make that order. If somebody rig if the court now found out that you rig your way into the election after 3 years, whatever you have taken, it becomes yours.
Yes.
That's what and that is usurping the judicial powers of the National Assembly by doing a legislation which is against the Constitution. That's the area. Yeah. Then on the issue of micromanagement of parties, look, the National Assembly, yes, I agree they have a power to make laws with respect to political parties, but they are to provide the basic principles. The issue of who will vote in a primary election
the groundwork, you mean?
Yes. Okay. The issue of who votes as a delegate in the primary election of a political party, that is purely an affair of a particular political party. I can have my own party and say that the only person who will vote is me and my wife. Okay. And if any feel that he wants to join, so be it. Or me and my family. You can have your party and say whoever is in the party is going to vote. Or you said, okay, we have this party, each head of household is going to vote. Okay. It's yours. But now the National Assembly is saying, no, if you want to do indirect primary election, all those who have one way or the other served in the National Assembly become members of as a super delegate. Why will you provide that? This is selfish. Okay. So the fact that somebody served in the National Assembly, he will just go and stay. Anytime there is an election, or any party he joined, he must be a super delegate in that party. That is micromanagement of political party.
I understand.
It doesn't make sense. Or saying that the party cannot provide any other qualification for people who want to get the party ticket apart from those that are provided by the Constitution. It doesn't make sense because, look, okay, the Constitution says for you to contest an election, maybe a House of Reps, you must be 30 years, you must have a qualification into at least a secondary school certificate or a living school certificate. Fine, but you join my party. I say, no, apart from that, for you to say that you want to get the ticket of my party, you must have PhD. What is wrong with that? You are not participating in the election. I'm saying I'm not giving you my ticket to run the election. You must have PhD. Now the National Assembly is saying, no, a party cannot say that. It doesn't make sense.
Yes, I understand.
And now saying that it is putting a cap to the money parties will charge for those who want to seek office on the party doesn't make sense. Okay. I can say I'm giving whoever wants to contest in my primary election, let him come and participate free of charge. The other party can say, no, if you want to participate in the primary election by a political party, you must pay ₦1 million or you must pay 10 million naira. It's unfair. But
political parties right now are saying even women, like the APC, for example, is saying women can get their nomination of interest from free of
50%.
Yes.
2014 is free, but now 50%. But now with the new Amendment Act, with the new Electoral Amendment Act, they want the president to sign. They are saying that they make a provision putting a cap, saying that if you are contesting for president, you should not be charged more than 10 million naira. Okay. If you are contesting for House of Reps, you should not be charged more than 500,000. Okay. It doesn't make sense. These are internal affairs of a political party. That is not what the people in National Assembly are voted to do. They are voted to do serious work. Okay. And this is inimical to democracy. And this is also a travails of their powers under the Constitution. And more especially this issue of trying to usurp the powers of the court. I think these are issues that Nigerians must now look at the Electoral Amendment Act 2018 to critically examine it, because Nigerian people will have this problem. We don't look at provision of the law when we are supposed to do, when they are within our cycle of influence, unless they come into our cycle of concern. Now we say, how did it happen?
After it has happened.
Yes, and it is in a situation whereby it will be difficult for us to do anything. But now this act is before the president for him to assent. Let us, all of us, find time to please study the act from the beginning to the end, whether, yes, it is in tandem with the constitution of the country, whether it is aimed at promoting democratic principles in the country, then we ask the president to sign. But if it is done for a selfish interest of some few people who by providence they found themselves in the National Assembly today and want to impose themselves as being critical stakeholders of a political party, even against the wish of the members of the political party to the end of their life, that is not what intended to at their legislative powers. If we find that this act is intended to usurp the powers of the judiciary to do their work and exercising their inherent powers as provided under the constitution of the country, that is going far out of the powers of the National Assembly. And these are issues that Nigerians must be alive to their responsibility, must be abreast with. But unfortunately, we always keep quiet. It's when it happened, now later we come and start saying that, how did this happen? This is why we as NCAN, we feel we have a duty to bring this issue to the fore, for the members of the country, for the populace to know that there is a danger in what the National Assembly is trying to do, and all of us have a duty to make sure that we do not allow the National Assembly and the president to flank this country into such an undemocratic legislative tenure, which will really not help in our democratic evolution as a country.
Thank you, Barrister Sanusi Musa. Sanusi Musa is the National Coordinator, Nigeria Consolidation Ambassadors. And on this note, we come to the end of Situation Room, coming to you from People's TV. My name is Francis Etuko. Until next week, same time, we'll bring you more interesting political issues and even economic issues cropping up in the polity. I want to say stay with the best. Good afternoon.